Okay, hello everybody, and welcome to Moving Families Forward. My name is Liana Rivera, and I'm the marketing assistant here at the Williams Law Group. I know what you're all probably thinking. Wait a minute, where is Allison? Who are you? Allison is actually the owner of the Williams Law Group, and she is usually our host on the Moving Families Forward Facebook Live show. But Allison did have a scheduling conflict tonight, so she asked me to fill in. So I am more than happy to fill in on her behalf. You will be missed, Allison, but the show must go on. So I am really excited about the topic that we're going to be speaking on tonight. I think it's a topic that a lot of people really don't talk about, really don't think about. You know, some people may say that will never happen to me, but you never know. You never know when you're going to get a caseworker at your door, asking you questions. Basically, what we're going to have tonight is our special guest talk to us about what is the process? What do you do when DCPP comes knocking? So I would like to introduce all of you to one of our very special senior associates of the Williams Law Group, and she's one of my dearest friends, Victoria Miranda. Welcome, Victoria.
Hi, everyone, and thank you for having me on tonight.
So I'm really excited that Victoria is on with me. We go way back. We actually were the only two people for a while at the Williams Law Group. We saw a lot of people come and go, but we have been here, and I'm really really grateful that she can be on here tonight. So Victoria has been with the Williams Law Group for 4 years now, and she has been a family law attorney that has represented many parents who are going through investigations with DCPP. So Victoria knows her stuff when it comes to DCPP. And I want to let you guys all know what exactly DCPP means. DCPP is the Division of Child Protection and Permanency. You may know it as DIFUS or CPS, Child Protective Services. So if we ever, talk about DCPP, that's what we're talking about. So before we jump into our segment tonight, I also wanted to let everybody know that Victoria was voted one of New Jersey's best lawyers for family in 2018. And she was actually also voted as a Rising Star attorney for super lawyers in 2017 and 2018. So kudos to you, Victoria, on your many accomplishments. That's definitely something to be proud of. So before we start, I want everybody to know, what sparked your interest in becoming a family law attorney?
Sure. So it was actually a professor I had in law school. I took the course in family law my first year there, and she was amazing, and she made it so interesting, and she made you want to help people. So I wound up interning for her for the rest of my law school career, and I was able to go to court and see all of these cases, and I knew that when I graduated that I wanted to continue to help families and make sure that no matter what type of situation they found themselves in, that they had a strong advocate to help them through it so that everyone would be better off by the time the case was over. And then I found Allison, and the rest is history, and I've been doing this ever since.
All right, well, that's great. I can really hear, how interested you are in that and your passion, with just assisting families whenever the division becomes involved. Because let's face it, it can be very overwhelming, very scary. What do you do? When the division comes knocking at your door. So I'm sure you've seen it all when it comes to DCPP. So why don't we start our segment for the night? So I have a question for you, Victoria. What does it mean when the division opens an investigation? What is the first thing that happens that parents should know?
So the division opens an investigation when they receive a referral through the child abuse hotline. So that means that somebody has called the 800 number and made an anonymous allegation against you of abuse or neglect. So that's how the process starts. And then after receiving that referral, the division is mandated to open an investigation. And their first step is going to be coming out to the home to talk with the children and with the family. So that's how it gets started. And they normally do have to come out within 24 hours. There are certain guidelines that let them come out within 72 hours if it's not emergent, but you will see them within the first couple of days.
Okay. And are these reports that are made to the child abuse unit, are they anonymous? Can anybody just pick up the phone and call and make a referral for somebody who they think is abusing their child?
So unfortunately, they are anonymous. And unfortunately, really anybody can call the hotline. And certain people are what are referred to as mandatory reporters. So when a school official, a teacher, an administrator, or a doctor or nurse has concerns that there's abuse or neglect happening, they by law have to make a referral to the division. So normally we don't really know by name who made that referral. Most of the time you can kind of figure it out, but
Right.
you will not get confirmation on that.
Gotcha. Yeah, that must be really tough sometimes because if it's the same person who's making a referral over and over and over again, it's hard to fight. The division has responsibilities to come out, do an investigation because the bottom line is you really never know. So you always want to be safe than sorry. So
Exactly.
can the division show up at anyone's home unannounced?
Yes. So the division is permitted to show up at your home unannounced. And at the first visit, they always show up unannounced. So it is very rare that you know they're coming. And that's because they just received the referral, and by law, they have to come out and see the children right away. But normally, after that first visit, it's within the discretion of the caseworker that's coming out to then be able to call in advance if they have to come see you again. But that first time that you're seeing that person is going to be completely out of the blue. They're just going to be knocking on your door, which is very scary and stressful, which is why we're going to try to help some people out tonight and tell them the best way to handle it.
Yeah, absolutely. I think it's very important. So what happens when the division comes to your home, but you're not home? What is the process that happens?
So in the case where the division caseworker comes out on the first visit and you are not there, you will come home to find a business card left on your door or in your mailbox with the caseworker's phone number and name, asking you to give them a call back. That's one way that some caseworkers will handle it. And then from there, they'll schedule a time to come back, or sometimes they'll do a second unannounced visit. But these caseworkers, they have a lot of cases. They don't necessarily like to waste their time. So if it's a scenario where you're not home, they're going to try to make it where they know they're coming out and you're there.
Right. Yeah, that must be really overwhelming for people. They didn't expect somebody to come at their door. What do you do? So I'm really glad that we're answering these questions tonight because, like I said earlier, a lot of people sometimes don't even think that it's going to happen to them. So we all just want to, welcome you all to the show, and we all just want you to, even if you yourself are not going through this, we want you to share. Feel free to share on your Facebook page, into a group that maybe a lot of people value all of this information. You never know who may be going through this. So I think it's good that we're talking about this topic. Sometimes a lot of people don't want to talk about it. So I think it's really good. So what do you say to somebody when they are trying to figure out whether the division should speak to their children alone?
So like we just talked about, when the division gets their referral and they come out that first time unannounced, they are going to ask to speak to the children. That's one of the things that, per their regulations, they have to do. So unfortunately, most parents in that situation are not going to want to let a stranger talk to their children unfortunately, you have to let them. So the whole purpose of the division caseworker coming out that first time is to see the home and talk to the children to make sure that there is no emergent safety concern. So sometimes when they're receiving a referral, it's because something really serious might be going on. So they have to be able to sit down, speak to the children alone, so that they know nobody is coaching them or telling them what to say, and to make sure that the children are safe, because that is the division's job, to make sure that children are safe, and have a safe home to reside in. So the parents will have to let them speak to the children. Those interviews with the children really don't last that long. I mean, we're talking about kids. They don't have too much to say most of the time because they're asking very standard questions. Like I said, they're just really gauging, is everything okay at home? Is there anything emergent that I have to be concerned about?
Right. So basically, if a parent has a caseworker at their door, you would recommend that they let the caseworker into the home, correct?
Yes, you should definitely let the division caseworker into your home. That first time out, they have to, as I said, talk to the children and see the home. If you turn them away, if you don't let them come in, they do have the ability to go to the local authorities and be escorted back to your home with police officers, which can make the entire experience much more traumatic, not just for you, but for your children, because now some strangers coming into their home and now they're there with police officers.
Right, exactly.
So we don't necessarily want to put children in that type of a scenario.
Yep, absolutely. It's scary. I mean, imagine for the parents, but imagine for a 2-year-old or a baby, it can be a very scary process.
Exactly.
So can the division, and this is another thing that I'm pretty sure a lot of parents are so not comfortable with, can the division visit your children at school and interview them at school without notifying the parents? Because I'm sure that happens.
Again, unfortunately, that is something that is within their authority. So, whenever the division is investigating an allegation of abuse or neglect, as I said, they have to speak with the children. And one way that they do that in order to obtain truthful statements, is to speak to them without the parents present. And they can show up at school, or even a daycare, and speak to your children there. And unfortunately, we see caseworkers doing this in order to avoid having interference from the parents when they're trying to have those discussions with your children. And while it's upsetting to the parent and frustrating that that's been taken away from you, the authority to say, no, you can't speak to my child when they're at school, the division does often use that method, and they're well within their rights to do so.
Yeah. I can just imagine, you get a phone call, or, it doesn't even have to be a phone call. Your kid can come from school and say, "Hey, mom, dad, I was interviewed today." And I can just imagine, what's on the parent's face. Like, what do you mean you were interviewed? Who were you interviewed by? Why didn't the school notify us? So there can be a lot of questions. And without the help of a family law attorney, it can be very, very overwhelming. You don't want to go through these investigations alone. You want to make sure that you're doing everything you can to protect yourself, to protect your family. So I just want to pause for a second, and I want to just thank everybody who is joining us today. We thank you so much for showing up and for tuning in. We have our special guest today, Victoria Miranda. She is one of our senior associates at the Williams Law Group, and she specializes in child abuse and neglect cases, and she helps people anytime the division removes children, puts them in foster care, and she tries to reunite families as much as she can. So I know that you're really passionate about that, Victoria, and we want to thank everybody this afternoon or this evening. If you have any questions pertaining our topic, please feel free to put your comments below. We'll try to get to them as soon as we can. the next question that I wanted to ask you, Victoria, is who else does the division need to talk to in order to finish their investigation?
Okay. So, as I said, they have to speak to your child or children, depending on how many children you have. And they are also going to speak with both parents. So, whether you are married, divorced, never been married, live separately, they will speak to both mom and dad. And if there are step parents, they may want to speak to the step parents as well. Really, anybody that's in a caretaking role for that child. Those are the immediate standard people that the division will interview. And then, depending on what the allegation is, if it's let's say, an allegation of neglect, they may want to talk to a pediatrician. If it's an allegation that you're not up to date on your child's vaccinations or up to date on wellness checks, they're going to want to speak to the doctor,
Right.
or the children's school or guidance counselor. Really, anybody having any information on what the allegation is.
And I'm sure a lot of parents are uncomfortable with that too, right? It can be a very uncomfortable process. I want to see all these records. I want to see the medical records. It almost sounds like they did something wrong, even if they didn't do anything wrong, and that can do one of many things, but that can make them take a pause and be like, wait a minute, do I have to sign this? Do I have to do what they're asking? And that can just, make somebody have all these questions, and it can make somebody make the wrong decision, especially if they're being peer pressured or if they're being forced to sign something that they're not really comfortable with. So what would you recommend to anybody who is, having a hard time understanding, number one, what the division wants, why they're involved? Because I know sometimes they're not always, open about that up front, why I'm really here, even though I know they're supposed to, mention that at first. But what would you recommend, or what would advice you would give to somebody who's just signing stuff, they're not reading it, they're just going with the flow? What would you say to that person?
So, unfortunately, we see that pretty often, where you're in the moment and you are afraid and frustrated and stressed out, and you signed a bunch of papers and you have no idea what you signed. So that's a normal scenario. And normally, in order to complete an investigation, the division's really asking for two things from you. One, the release from a pediatrician, and two, a release from the school. So is your child going to school? Do they have a lot of unexcused absences? Has the school ever had concerns of abuse or neglect? And the same thing with the pediatrician. Has there ever been a concern that this child is being abused or neglected? Are they up to date on everything they need to be? And they're actually pretty standard forms that the division sends out. So it's not always a conversation. Sometimes it's just that form that a pediatrician's office fills out, yes and no, and they send back. And that's pretty standard. What you then have to watch more of is if we're talking about an allegation having to do with a mental health issue, and they want to start seeing your medical records. These are not just things that you should sign over without thinking them through. This is when we advise that you should consult with an attorney who deals with child abuse and neglect, who can guide you through the process of an investigation to make sure that you're not just signing over all of your medical records or all of your history, that you are giving the division just what they need to be able to investigate the allegation. And that really comes from the interview that the division's having with the parent, which we haven't spoken about yet. But the division tries to do that first time that they're coming out to see you.
Yeah, wow. So how long does an investigation usually last? I mean, what is the normal timeline for an investigation, and if you have seen them go longer than that?
So the normal timeline pursuant to the regulations that the division has is 60 days to complete an investigation. And that is from the day the referral was received by the division.
Okay.
About 60 to 70% of division cases probably end within that 60-day time period. And when I say that, I mean the investigation starts on day 1 and ends by day 60. Okay. But there are those cases that go farther than 60 days. And when the division reaches that 60-day mark, they do have the ability to request an extension of time. So normally a 30-day extension. And you see that in cases where they're asking you for those medical records that we just talked about, or they need confirmation that you've seen a doctor or done something that you were supposed to have done before they can close that investigation out. And before they even get to that point, they're going to want to speak to you. And a lot of people will ask, do I really have to talk to them? Do I have to sit down with them when they come into my home and barge in? Do I really have to sit down and be nice and have a conversation with this person? And my advice is always, no matter what you are feeling about the division coming into your home, the best course of action is to be polite, be pleasant. I tell my clients all the time, put on a fake smile and be as nice as you can. And then when they leave, you can scream and yell and say whatever you want. But when they're there in front of you, play nice.
Right. Yeah, it's so true, because, a lot of people can get, into the moment, and they can, express themselves very differently than how they are, because they're just overwhelmed, because they're just scared. And it's good to take a step back, take a pause, and just say, okay, like you said, let me just get over, let me get through this, and, answer their questions. But would you also recommend, if somebody made a mistake, because we're all human, it happens, what would you recommend they say to the division if they're not comfortable in answering a question?
So that is completely normal. And even though I said that they have to speak to the children that first time that they come out, mm-hmm. You do not have to answer questions that first time that they come out to see you. You can tell them politely, I understand that you are investigating and I understand that you have questions for me, but I do not feel comfortable answering those questions without an attorney present. And you have the right to go consult with an attorney and have that attorney sit with you during that interview. Either way, there are certain questions that the division's absolutely going to ask you. And as I said, stay polite, tell them you want your attorney present, and then that interview is then scheduled between the attorney. When that happens, you go there with your attorney, and the caseworker is there with their attorney, because the division has attorneys too. Right. So both attorneys are present, and the caseworker then can ask you their series of questions they need answered in order to wrap up their investigation.
Yeah. So what is the name of the attorney for the division, so people know?
So the division attorney is called a deputy attorney general. You will hear a lot of people refer to them as DAGs. It's just a shortened word for deputy attorney general, but they work for the attorney general's office, and they only represent the division. In cases like these, the division attorneys don't always get involved in an investigation until you get an attorney involved in an investigation. And I see a lot of people say, well, wait, doesn't that show them that I have something to hide, or that I did something wrong because I'm getting an attorney involved? And my answer to that is no. That doesn't mean that you did something wrong. That means that you understand your rights.
Absolutely.
And it means that you want to protect not only yourself, but your children. And you want to make sure this goes as smoothly as possible. And having the attorneys involved sometimes can fast track the case. and make them focus on really what the issue is, because we can get those questions answered quicker, find out if they need any of those releases we talked about from medical providers, and make sure that we're signing the right ones, to come to some type of resolution in their investigation.
So the division has a lot of power, we have seen. And, sometimes once upon a time when I did intake for the firm, I would hear a lot, well, they told me not to get an attorney involved. You don't want to do that. And I'm like, well, why wouldn't you want to get an attorney involved? It seems like everybody's pointing the finger at you. You don't really have support. You definitely want to understand what's going on, because I'm pretty sure it's not clear cut. When the division becomes involved, I'm pretty sure a lot of people have, questions that they need answered that the division doesn't always provide. So when they come to our firm, when they speak to somebody, they start to realize, wow, I really need somebody because I don't know what's going on. So it's always good to have that support, to have that person to kind of just guide you through that process, because you don't want to do it alone. And that's something that I do want to stress to everybody who's watching. If you are dealing or have dealt with DCPP, or if you know somebody who is, you don't want to do it alone. These are your kids, and or your grandkids, or your niece or your nephew. I mean, I'm not a mom, but I do have a niece and nephew. My sister has 2 kids, and sometimes I just think back at them, and I actually have pictures of them everywhere on my poster board, because, I think about them, because I put myself in people's shoes sometimes to kind of say, okay, well, how would I feel about this? Or, because I love them, and I care for them, and I'm like every other parent does for their children. So I think it's really important to, have this information, to store it, to, use it if you ever need it, or share it, like I said, on your Facebook page, or if you ever know somebody who's dealing with that, you can always refer them to our firm, because we're more than happy and more than willing to educate, because the more you are educated, the more you know, and the more value you have from trying to escape DIFUS, or trying to be in an investigation. So Victoria, I know that we spoke about basically a lot of different things already in regards to the division, what their process is. Do you let them in? Do you let them speak to your children alone? How does an investigation end? What happens that the parent or the guardian is notified that the investigation has ended?
Well, before we get to the end, just something that you said previously, and
Sure.
I would like to stress, is
Absolutely.
you were completely right when you said, the caseworker will come in and they will say, oh, you don't need an attorney. And the one
Yeah.
thing that people should be aware of is caseworkers will be nice to you, and they will act like your friend, and they will give you advice on how you should finish your case or work with them. And while that can seem really nice in the moment, and you are putting your trust in this person, you should also keep in mind that they have a job to do, and that is to investigate whether there's been abuse or neglect, or there's a safety concern for your children. And they're not there to be your friend. They're there to do their job. So you do want to keep that in mind when they're asking you to do something. And even during those first couple of visits, when they're first coming out to the home, they're going to ask you to do a walkthrough of your home. And most people would say, what do you mean, walk through my home? And they're doing that because they have to check and see if there's a safety concern in your home. So they're looking for certain things. They're looking to see, does your child, or do your children have somewhere to sleep? Is there adequate space in the house or the apartment? Is there food in the cabinets in the refrigerator? Is there fire alarms in the house? If you have a balcony, is there a door that locks to stop a child from running out onto that balcony and getting injured? So they're looking for those safety concerns when they come in. They're looking for those hazards. Now, most of the time, there's not going to be any glaring hazards. But they have to do that walkthrough, even if when they walk into your front door, everything looks perfect. They're still going to ask to see the rest of your house. So that's something to be aware of. Just like I said, they're going to speak to your children and they're going to want to speak to you with or without an attorney present. So those are things to keep in mind as far as the beginning of the investigation.
Yeah, thank you for that information. It's always important, you know. I have a question for you though, Victoria. What happens, I mean, in most cases, you know, the division comes out. They just want to make sure that there's no concerns, that everything's okay with the children. What if they do find something? What if they do have a concern? You know, what if they don't see any food in the refrigerator or they're not sure where the kids are sleeping? What happens then?
So investigations can go in many different directions. You know, we're talking about your standard, what do they do when they come out? If they come out and there is a safety concern, the division caseworker that's there will normally call their supervisor, but they can make certain decisions on their own. So if they feel there is an emergent situation that a child is at imminent risk of harm, so something can happen to that child, and they don't feel comfortable leaving that child there, they can execute something called a DOD, which is an emergency removal of your child. If they feel there's an issue, but it doesn't rise to that emergent level of removing a child, they can ask you to sign something called a safety and protection plan. And that's to put certain things in effect until they can get more information that they're looking for. So is there a substance abuse issue in the home that requires a parent to maybe only be supervised around their child? Is there an issue like you just talked about where this house is not safe for the child to sleep in because they don't have somewhere to sleep, or there's no food, or there's some type of hazard? Can the other parent take that child for the night if they don't live together? Is there a family member that can take the child until there's a resolution? And they will ask you to sign that safety and protection plan. And what a lot of people don't know, and you know, we could go on for another hour about this topic, but I think the really important thing to know is a lot of people will come to us and say, the division showed up at my door, I let them in, I didn't know what to do, and they had me sign this paper, and now I have to be supervised around my child or something along those lines. So what do I do now? A safety and protection plan lasts 10 days. The division then has to either enter a new safety and protection plan after those 10 days, or they have to bring you to court to have a court order you to do something. And exactly. And if you find yourself in that kind of a situation, that is really when you need to consult with an attorney who knows what they're doing in this area of the law, because you do not want to go that route alone. It's scary and it's terrifying, and it's not a fun time in anyone's life.
Yeah, especially for your children, right? Because we forget, you know, it's the children who are being impacted as well through this situation. So I know you were talking about a safety protection plan,
Yes.
and how people have 10 days, I believe you said, to, you know, comply with it. But what happens if somebody doesn't? What are the, you know, what happens then and there if somebody signs it, agrees, and then doesn't follow through with it?
So unfortunately, in that type of a scenario where the division is asking you to sign a safety and protection plan, most of the time that will involve one parent being supervised around the children. And even if you agree and then decide, I'm not going to do that, I'm not going to follow it, the division can then do what I refer to as the emergent removal of the child and take that child into division custody. And when they do that, they have to be in court within 2 days of that removal. But that's 2 days that you're waiting to find out what's going to happen. Is your child going to come home? Are you going to have to go through a court litigated matter? And there's no definitive timeline going forward from there on how quickly your child can come back to you.
Yeah, that's really sad, when you think about it. But what happens in that time? Does the parent at least get to see the child at all? Is there any, supervised visits or visits that they can have while they are not really having that time that they usually have with their child?
Mm-hmm. So the division, even when they do an emergency removal of a child, they have an obligation to find family members that can care for that child. So your child doesn't necessarily get removed and put into a resource home, or a lot of people refer to it as foster care. They will ask you if you have relatives willing and able to take your child for the time being, grandparents, aunts, uncles, even family friends, because for a lot of people, their friends are their family.
Right.
So they will ask you those questions before putting your child with a non-relative. And then they will make arrangements for you to see your child. We always make the push for any child, obviously, but it's especially when we're talking about an infant, we want to make sure that you're seeing your child as quickly as possible, because it's traumatic not only for your child, but it's traumatic for you too. And I think sometimes it's more traumatic for the parents because they're the ones that are really understanding the situation. So you want to make sure that you are on top of it as quickly as you can be, and that you're getting an attorney involved as quickly as you can.
Agreed, 100%. So I'm just going to go to our comments a little bit. We do have a couple of questions.
Sure.
Safety and protections plans, like you said, we just spoke about it, they last 10 days.
Yeah.
But what if they expire with no further action from the division? I'm pretty sure that happens a lot. Does the person just stop complying? Do they just go on with their regular life? How do you go about that?
So that is sometimes a tricky situation. They do lapse within 10 days. And most of the time, if it's going to lapse and the division knows that and they don't have concerns, they will tell you it's going to lapse and it'll expire.
Okay.
Other times, the division is still actively involved with you and your family, and they're still asking you to comply with requests and services. And it's clear that through their actions, they have no intention on letting that safety and protection plan expire, but they're also not doing anything to put in a new one in place.
All right.
Because while we know they last 10 days, your normal person does not know that they last 10 days. So unfortunately, the division can get away with keeping that in place much longer because someone who hasn't read a blog or watched a video or consulted with an attorney, they don't know that it goes away so quickly. So I would never suggest to anyone to just say, oh, my 10 days is up, forget it. I'm just not going to follow this anymore. If the division is still involved in making it clear that they're asking you to do something, you need to have that conversation.
Absolutely. Like I have urged everybody, if you are going through this, if you know somebody who is, you don't want to do it alone. Make sure you understand what your rights are. Make sure you're protecting yourself, your children, your family. Because like I said, it can be very overwhelming. Some people say, this is my kid. I can say what I want to do with my kid. Nobody can tell me what to do. That's completely false. I mean, especially when you are involved in an investigation. So this is all to be to educate the public as to, what your rights are, what to do when DCPP comes knocking. Because a lot of people are scared to open that door. They're scared to, find out why they're there, who made, I know they're usually anonymous, but, what the allegation was. And sometimes a lot of parents, they can't believe what the allegations are, or, if a neighbor called or if somebody at school called. like we had talked about before, it can really come from anywhere. So you want to just make sure that you understand what's going on. You want to be in control of the situation. So we do have another question. When DCPP makes a bad call, what can you do? Are you stuck with DCPP's conclusion? Do you have any other, options in regards to that?
So we didn't even get to our how does it end, but this is the perfect segue, I think, because I completely ignored your question before. So sorry.
No worries. It's okay.
But when the division is finishing their investigation, it has to end. It ends in a couple of different ways. So they can close their investigation out and that's it, or they can ask for services to be in place. But if it is an abuse or neglect referral, so they're asking you questions about abuse or neglect, the case has to end with a finding. And a lot of people have no idea what that means, and they read these letters and they are frightening.
No clue, right?
Have a lot of language in there that's hard to follow and doesn't make sense. But there are 4 findings that the division can make. So if they are investigating an allegation of abuse or neglect and they find that there has absolutely been abuse or neglect, and they believe there's aggravating circumstances. So we see that in cases where there's been excessive corporal punishment, some type of physical abuse that results in a fracture or a broken bone, or marks on the body, sexual abuse cases, you will get a letter saying that you've been substantiated for abuse or neglect. That is the highest finding. The second highest finding is an established finding, and that is also an abuse or neglect finding, but they found that there were mitigating factors, meaning this was a one-time incident. There were extreme stressors happening in the family that led to this, and the division doesn't believe it's a recurring pattern. Those are the 2 abuse or neglect findings. When you get a finding like that, you are permitted to appeal that directly to the Office of Administrative Law. You are entitled to a hearing where the division will have to present evidence and witnesses to prove that there was abuse or neglect. So that's your recourse for those 2 findings. The lower 2 findings, you will receive a letter and you will believe that you don't have an avenue of recourse. So the third finding is a not established. We see these very often, and that's when the division says there was no abuse or neglect, but we feel that the child was harmed or placed at risk of harm. And it's very non-committal language. They don't explain why you placed your child at risk of harm or harm them. That's all they'll tell you. And they will tell you that you don't have the right to appeal, which is incorrect. You can appeal that decision to the appellate division. So in New Jersey, there are Superior Court and then the appellate division and the Supreme Court. But you can appeal that right to the appellate division. You have 45 days to do that. And you can argue that the division's finding is incorrect. The lowest finding is an unfounded, and that means they came out, nothing's going on, they close their case. You don't need an avenue for recourse to that one because there's been no finding against you. And the division does have to expunge those records within 3 years, which was a lot of information.
Yes, but it was very helpful information. So a few questions. So basically, I'm a parent. I had DCPP come to my door. I know I did nothing wrong. It's just somebody thought something happened. It didn't happen. The division does an investigation. They close it out. I'm supposed to be receiving an unfounded finding from, I know I didn't do anything wrong. I would never do anything wrong to my kid. It's just a misunderstanding. What can I do if I get like a substantiated finding? If I know for sure I did not do anything to harm or abuse my child, what can I do at that point?
So you need to appeal that finding right away. Like I said, with a substantiated or an established finding, you only have 20 days to send in that letter, which is not a long time. It seems like, oh, okay, I have 20 days. That 20 days goes by very quickly.
Right.
It is very easy to miss that deadline. And once you miss that deadline, it is very hard to do anything about it. So whether you are sending in that letter on your own at first while you're finding an attorney, or you find an attorney right away to send that letter in for you, you need to be appealing that decision.
Absolutely. Yeah, you don't want it to affect anything else. I mean, I know for substantiated findings, speak to us a little bit about that. I mean, does that go on any records? Does that affect what jobs you can have in the future once you do get a substantiated finding? Tell us
So
about that.
a substantiated finding, and again, there's a lot of information to give on this topic. I'm going to give a snapshot basically, but if you have more questions, obviously feel free to give us a call, or give anyone a call who knows what this type of law is about. But a substantiated finding results in your name going on something called the Child Abuse Registry. That's a registry, a list held by the Division of Substantiated Abuse or Neglect. Division records are confidential, so they can't just be given out to anyone. Those records are sealed. But if your name is on the registry, certain places do have access to that information. So if you work for a licensed daycare facility, a licensed nursing home, anything having to do with elder care or children, if you are trying to become an adoptive parent or a resource parent for another family member, these are all places that automatically have access to that child abuse registry. And if your name is on there, you will have a very hard time adopting a child or becoming a resource parent. The division won't let you become a resource parent. And certain jobs, as I said, will have access to that, and it can be a disqualifier for future employment. And you see that a lot in, as I said, licensed daycares and licensed nursing homes, when you are responsible for really taking care of a child or the elderly.
So what I have heard a lot is people would get a substantiation letter from like 1990, let's just say, way back when, and they'll call our office because they're trying to get a job as as an assistant in daycare or something that has to do with children. And the daycare center or whatever job will do a background check, and then they find out that they're in the child abuse registry. So
Yeah.
what do they do then and there? Can they still appeal it at that time? What if they say they never got a letter? What will happen?
So the standards are very different now than they were 20 years ago. And we've actually had quite a few cases like that. And we've been successful in appealing those findings. So unfortunately, 20 years ago, even 10 years ago, there was no regulations on how those letters had to be sent. Mm-hmm. So today, they have to be sent by regular and certified mail. So there's proof that you received that letter. There's no proof from 20 years ago because the division wasn't obligated to prove that they served you with that letter. So my advice is, if you are applying for a job or trying to become a resource parent for a grandchild or a niece or a nephew or a family friend, and all of a sudden you learn that you have this substantiation that you had no idea about, contact an attorney because they can still try to appeal that. We can never guarantee that the finding would be reversed. But as I said, we've been successful in that, and we've been very successful in still getting those issues heard because of that lack of proof that they actually informed you that you had that finding against you.
Yeah, it's
Yeah.
really important information. I mean, if you don't remember, I know a lot of people that, call our firm and they just don't remember or have no clue why they are on the child abuse registry. So yeah, for everybody who's watching, everybody who's tuning in, if you're finding this information helpful, let us know. We do appreciate your feedback. We're going to be wrapping up in a little bit. We do have one more question for you, Victoria, if you don't mind.
Not at all.
So, does the child ever get to go home if the abuse is substantiated? Does that ever happen?
Yes. Yes. So I think a lot of people hear substantiation and think I'm never going to get my child back. And that's not accurate. Um, Even if you have a finding of abuse or neglect against you and it's been substantiated, and let's say you went through and it was heard in court and you even had a trial and that finding was upheld, that does not preclude you from getting your child home. All that means is that if the case is in court, the judge is going to want to see that you are cooperating and complying with any services that have been recommended. So whether that's substance abuse treatment, if it's a substance abuse problem, mental health treatment, if there's an issue, so individual therapy or psychiatric care, or going through a parenting class.
Right.
The court's just going to want to see that you are doing what you need to make sure that you have a safe home for that child and that you're going to remedy the issue that led to the division's involvement. And as long as you show that to the court, your child will come home. If it's in litigation, I'm not saying it's an easy road or a quick one, but I'm saying that you absolutely can get your child home. And, we really only see cases where they're talking about not letting a child go home when a parent is really just unwilling to do what they need to do.
Right.
To better themselves and to do what's in the best interest of their children.
Yep. Wow. So that's a lot of information, but it's valuable information. I know that all of our viewers, whether they're on the live today or they see it tomorrow, it's definitely information that they need to know. I mean, like I said earlier on, sometimes we don't think about these things. Sometimes we say, no, that's never going to happen to me. But you never know. I mean, you could be doing the wrong thing at the wrong time, something happens, and then you find yourself in the situation. So thank you, Victoria, so much for your time today. For anyone who is interested to learn more about Victoria, I am going to be posting her profile on our website, the comments below. So feel free to, message her if you feel like this is something right in your alley. If you need her assistance, if you need our assistance, feel free to, let us know. If you know someone, like I said earlier, who is going through an investigation, please urge them not to do it alone. Our attorneys are here to help you. We understand it's not always easy to talk about certain things. Everything is 100% confidential in our consultations. Our attorneys, most of them are, they have families of their own, so they know how to deal with the division if you are going through that. So we do want to thank all of the people who have been watching this evening. We thank you so much. Victoria, you were an awesome guest, so you should be on all the time, always answering my questions.
Thank you for having me. It was
Of
excellent.
course. And we would, I'm sorry, go ahead.
No, and I am more than happy to answer any questions anyone might have.
Awesome. So like I said, you don't want to do it alone. Get a family law attorney, specifically who specializes in child abuse and neglect. I've heard a lot of stories where, DCPP becomes involved and, Sam so-and-so, they just hire any, Joe Schmo out there. And you don't want to do that. This is important stuff. This is your children. You definitely want the best attorneys on your side. So we would like to thank again all of our viewers for tuning in. For anyone who has just joined us tonight for the first time, thank you so much for watching. Feel free to share our interview. You never know, like I said, who's going to be needing this information. or who may find this information valuable. You may not need it now, you may need it in the future, you never know. So we just want to prepare all of you, parents, grandparents, aunts, uncles, anybody who really has a child in their lives that they love and they want to make sure is being safe and healthy. So Moving Families Forward does air every Monday at 7 o'clock. So Victoria, like I said, you were a great host tonight. Thank you so much.
Thank you.
This information was really valuable, even to me. So I'm going to share it on my personal Facebook page as well. And, let everybody know who you are, what you do, and we appreciate you protecting the families of New Jersey and keeping the children safe. So
It
thank
is
you for
my
that.
pleasure. Thank you.
Of course. So we hope everybody has a great night. We'll be seeing you all next Monday on our next show. Have a great night, everybody. Take care.